fellow Florida Gator, Ms. Cammack, for her 5 minutes of questioning.
Thank you, Mr. Chairman. He did do it because you are a Georgia Bulldog. He's just much nicer than I am. Thank you to our witnesses for being here today. Obviously, college athletics is something that is all very near and dear to our heart. I'm very proud to represent the Gator Nation up here in our nation's capital, and appreciate everyone's contributions to this hearing today. I'm just going to start with you, Mr. King, talking about the SCORE Act and how the IIAA enforces rules on revenue sharing and NIL disclosures. Now, you flag the risk of constant litigation anytime the rules change. However, should we be thinking about how to structure the IIAA oversight to avoid these future lawsuits, for example, through transparency mandates or safe harbor triggers that are built into the federal law itself?
Yeah, thank you for the question, and you really hit on some of the key issues. So the IIAA, we'll just call it the College Sports Commission, or CSC, has been created to regulate in this area. You are correct that one of the concerns that I raised earlier, one of the needs in the legislation is to preempt the state laws, codify the rules coming out of the settlement, and provide protection so long as schools follow those rules, conferences, associations, that they will not be subject to liability. We need that structure to give this a chance to work. It is a really good settlement. I want to be respectful of your time, but it is, contrary to Mr. Human's views, there are some incredible positives in this settlement for athletes that I think no one 10 years ago would have ever thought. Things that were requested or put forth in legislation 4 or 5 years ago that have now been done, they need to be codified, revenue share, medical guarantees, post-participation, codify those things, and create a structure where this commission can enforce them, give them a chance to succeed and see what happens, rather than immediately being in lawsuits left and right while trying to start this new system.
Okay, I appreciate that. Now, of course, the bill would also require that student athletes disclose NIL deals over $600, as we've talked about a couple times here today. And it allows interstate, intercollegiate athletic associations to collect and share aggregated data. My question is this: now, under the framework of the SCORE Act, how do we ensure that the data collected through the process actually gets turned into useful, accessible, comparative information, both for schools looking to maintain compliance, for student athletes trying to understand if fair market value is there, or what oversight or reporting should Congress be considering to make sure that this isn't a one-way data collection exercise?
Yeah, so the data collection is an issue that really has not been talked about a lot, but I think it will be a huge advantage for athletes, for people on campus, but it will be respectful of the athlete's privacy. So it will be aggregated, it will be anonymized, you will not be able to learn specifically what Joe Jones gets from his university or he gets from this deal. That will be protected. But Joe Jones will be able to know what an average at his position for an Autonomy 4 school or for an SEC school, what is the average in NIL or in institutional rev share, those sorts of things. Likewise, their agents will have access to that information, as will the university. So it will be a much more candid discussion. Now, we're still working out the details on how that will be shared and with whom it will be shared, how public will it be, but respecting the athlete's privacy while giving everyone involved in this new system the information they need to make informed decisions, I think is a real benefit. And then obviously there's some legal concerns about how the information is shared as well, and we're obviously monitoring and aware of those. But I think it will be a huge positive for everyone when this information is shared.
Excellent. Well, and going completely in a different direction here, in talking about Section 3 of the SCORE Act, it says that under this legislation, it affirms the right of student athletes to enter into NIL agreements, which cannot be restricted by their school, the IAA, or the conference. And exceptions exist for schools that can restrict deals that, one, violate the student code of conduct, or two, conflict with the school's existing contracts. Now, I know I'm built for comfort, not for speed these days, but back in the day, I was actually cheering as an undergrad, and there was a situation where several of my teammates engaged in foxy football. It got into a gray area of the school's code of conduct. Under this, is there a preemption that should be required in this legislation? Because school code of conducts are all over the map. Is there something that you see being potentially problematic moving forward where maybe there's a bit of a gray area, maybe adult content that students may be engaging in, while lawful and legal, that could potentially become problematic moving forward? I'd like to open this up to the entire panel. I'll start with you, Ms. Montgomery. I'm sorry, quickly, because I got 30 seconds.
Yes, I do think that that could be problematic. Not only is this written here, but I think there's also currently an expectation when it comes to name, image, and likeness opportunities that they do not fall outside of the expectation code of conduct with institutions. With the example that you specifically raised, I do see that potentially being a gray area, one of concern.
Thank you, Mr. Huma.
I think a baseline good test could be if the school's not partnering with these types of industries for moral reasons and reputational reasons, that might be a good balance. But I think right now, as written, is very, very broad restrictions that really need to be reeled in.
Mr. King.
I just looked at the language quickly. It says an institution may, not shall restrict. So it's left to the campus. And I would imagine that in some parts of our country, what would be objectionable behavior to, let's say, an institution with a religious affiliation might not be a problem at all at others. So those can be made at the campus level based on institutional values, and also between the university and the athlete, depending on the circumstance. We've already seen very high-profile athletes sign shoe deals with companies other than the company their university is using. So I think rather than view this as, boy, this is a stonewall, there's no way that this will be handled at the campus level. I would imagine maybe in some areas a policy, but otherwise on a case-by-case basis.
And finally, and I know I'm way over time, she's going to go real fast, Mr. Chairman.
Very fast.
Thank you. I would echo Mr. King. Our institutions are so unique and so different. I come from a mid-major school that is very much smaller than the University of Florida. And what is okay in our university is probably different than what is okay at a big Power 5 school. And so it's really important that it's left in the institution's hands.
And I will
Thank you.
say that